Hello world, hello internet, hello Jason Isaacson. Thank God that whole White Lotus thing is over, so we don't have to talk about that anymore. Instead we have to talk about politics, because this is Paul Talks Politics, and I'm Paul, and I should probably be talking politics, and I will do. And today we're going to talk about liberty finds no refuge in the jurisprudence of doubt. And, full disclosure, I'm going to geek out terribly on this one because I can, and because I find it one of the most interesting aspects of US political theory, and particularly significant when it comes to trying to understand what the Supreme Court does in the American system. And spoiler alert, it does everything. All roads lead to SCOTUS, as I think my students are probably very sick of hearing me say. I'm going to explain what that means. I'm going to explain why I've got a photo of Sandra Day O'Connor up there, and I'm going to do all of that telling you how to answer basically any question on American politics as soon as we get back from the intro, and that's coming up right now. Don't touch that dial. See you in a second. And we're back. Thanks again to Oscar for the intro music. And we've got to talk about SCOTUS and the role that SCOTUS plays in American politics. And it plays a very, very big one. And given that it's so important, we do have to know what the law means. If you don't actually know what the law means, then how on earth can you be free? And this is what this code means. This quotation, means. This was used in Casey versus Planned Parenthood, of which more later. I don't know if it was actually Sandra Day O'Connor, but according to the internet, it's been allocated to her. And why not? Let's just stick with that in the short term. Now, I always like to start off with a bit of comparative theory. For those of you who are in the middle of your revision right now, it's the best way of checking your revision and building towards the exam. Now, of course, in the exam, we're talking here about the EdXL A-level politics exam. When it comes to the comparative, you've got two questions to do. The first one is a choice of two. The second one is compulsory. In the second question, you have to mention structural, rational, cultural. In the first one, you don't. And interestingly, I got into not a spat, but a spirited discussion with some examiners when we were talking about this. And I said, well, in the first one, why don't you use structural, rational, cultural? And they said, well, you don't have to. I said, okay, fair enough. But it does mean that you are going to be making discrete points and you don't lose anything by it. And there was a sort of silence. And anyway, you can read all of that. I'm just getting distracted because it still rankles. Anyway, that's the point. That's up there. You can read that in your own time. What I want to get into is this, the critical difference, if you will, between the United States, which we have at the top there, and the UK, which we have at the second bit. The first bit is that idea of constitutional review. When the Supreme Court is working in the United States, the judicial review that they are using demands that they hold all aspects of the state activity against the Constitution and determine whether or not it is constitutional. With Parliament, with the UK, the structure is very, very different. Here we have that concept of parliamentary sovereignty because we elected Parliament. Parliament is the only really democratic element of our entire constitution. And so what the court is trying to do there is essentially to determine whether or not state action is compatible with the will of Parliament. Does the state, whether that is indeed the government or in Parliament itself, are they acting in a way that is lawful? Now, I go into that in massive detail in my various videos on judicial review, and I'll link up to them wherever those come up, and do look at those and review them. But the key thing here is, in the British system, our courts defer to the elected representatives because the courts recognise parliamentary sovereignty and they recognise the fact that they have not been elected. No better is this demonstrated than in Nicholson in 2016, where the court refused to answer a question, deeming it a political question, therefore better answered by politicians. In the United States, arguably in Baker versus Carr in 1963, the Supreme Court was asked a political question. And rather than demurring and saying this is a political question, it should be answered by politicians, the court answered it. And if you want a detailed explanation of that, then I strongly advise that you look for The Political Thicket, which I will link off to up there, which is one of the most amazing podcasts I've ever listened to from the More Perfect series from NPR and the team at Radiolab. Changed the entire way I understand American politics. If you've got the time, I seriously suggest you invest in that time in that idea. Anyway, key point that I want to get across here is that the United States Supreme Court and the UK Supreme Court operate very, very differently in that one is upholding the Constitution and the other is upholding the will of Parliament. When upholding Parliament's will, our court is trying to make sure that the will of the democratic representatives is respected. In the United States, the Supreme Court has assumed a higher role, that they are the arbiters of what is constitutionality, of what is compatible with the Constitution. Now that's fine if you trust the Supreme Court. If you don't trust the Supreme Court, then things get very, very sticky very, very quickly, as we will discover. Fundamentally, it all comes down to this. What does the Constitution mean? Now, in the UK, because we have a parliamentary system, the Constitution is whatever Parliament says it is. And if Parliament does something that's not entirely clear, then the Supreme Court identifies when that's happened and Parliament gets to change it. In the United States, that's not the case. If the Supreme Court identifies that there has been state action, be that something coming from the executive or legislation passed by any one of the many legislatures out there that is incompatible with the Constitution, then they declare it incompatible and that's it, and that's the end of it. So the Supreme Court becomes the arbiter of what is constitutional and what therefore the civil state looks like. In the United Kingdom, the civil state is still designed by Parliament. Parliament creates the laws that we live by. The Supreme Court identifies those odd occasions when Parliament has acted in a way that is not compatible with its original obligations, specifically the Human Rights Act. But again, I'm getting distracted into all of that judicial review. Just look at my stuff on judicial review in the UK for clarity, because I don't want to get into the weeds and I'm in severe danger of doing that. What I want to focus on in this particular presentation is how the Supreme Court's ability to determine what the Constitution means that it is the single most important entity in the entire American political system. So let me try to explain what I mean exactly by that. Okay, let's be absolutely clear. I am a huge fan of the United States Constitution. It's a work of absolute genius. Perhaps not as much genius as the Declaration of Independence, but then that's setting the bar very, very high indeed. Now, accepting that it is a work of genius doesn't mean that it is the work of the infallible. And the Constitution is riddled with problems. Let's leave it at that. In some instances, you can say that it is subjective or it is vague. For instance, the Eighth Amendment, what is cruel and unusual? What does the right to bear arms or arm bears actually mean? In these areas here, we can see that the Constitution is open to different levels of interpretation. Coming over onto this side, it's subtly different in that the Constitution was the product of compromise. The Constitution was the product of a long, hot, sweaty, slightly drunk summer in Pennsylvania, Philadelphia even, where various compromises were made. And of course, when you have a compromise, you inevitably have tension. We have tension between the federal government and the state governments. We have tension between the different branches of government. We have different tensions between individual rights, collective rights, state rights, all of these different things. And where you have tension, you need resolution. And it falls on the Supreme Court in each of these instances to determine exactly where the line is. And I'm going to go into all of this in much more detail later, so I don't really want to dwell on too much on that right now. What I want to drill on is how we try to find, or what I want to try to identify, is how we establish what the Constitution actually means. And in that sense, we have really three main schools of constitutional interpretation. We have strict construction, also known as textualism. Then we've got originalism, and then we've got loose construction, or living constitution, to give it a different word. Now, you need to know all of these ones. Strict construction, nobody really does because it just doesn't work. You're stuck with the text. And as I said earlier, the text is not perfect, and so you can't literally hold to a strict interpretation of a text that doesn't make any sense. What we can also do is take the idea of the text and add to that some degree of context. So, for instance, one of the most important bits of context we've got is the Ninth Amendment, which says, look, here we are, we've been working all summer on this. We've come up with all of these different amendments, 1 through 8 in this instance, but that doesn't mean that's all of them. There may be others that we just haven't thought of yet, or we haven't got time to put down yet. So in the Ninth Amendment, they are opening the door, the Founding Fathers are opening the door to other rights that they have not quite listed there and then during that long, hot, sweaty summer. So even within the text, there is this thing saying, look, this is incomplete. And this needs to be put in context. There are going to be other things that we need to introduce that we just haven't got the time or the crayons to write into this particular bit of the Constitution. So this is what we would call originalism, which is, okay, this is what the Founding Fathers meant when they were writing all of this in 1789. We need to hold to this particular model. If we've got a problem with that, then we can change the text through the amendment process. That's originalism. The next bit is saying, okay, well, we've got this. We've got the original text. We've got that idea of constitutional context as well. But we acknowledge that the Constitution is very, very hard to amend. And so what we do instead is we try to stretch the Constitution as far as we possibly can. We need to stretch the Constitution so we can apply it in a 2025 context. That's the time of going to press. I've been doing this for a long time. But we can't be stuck in 1789, but we can stretch the Constitution to try to accommodate changes in society, changes in the state, changes in, whatever it is that's going on. And I'll explain how that works in context a little bit later. But obviously, every time we move in this, we're moving further and further away from what the text actually means, or what the text actually is, into what the text means. So that's the extent of our constitutional stretch. I could have explained that better. Perhaps the smart thing to do is to just keep on going and to try to explain it through the use of examples and evidence. Let's give that a go. So I mentioned the Ninth Amendment earlier, and in so many ways, understanding what the Ninth Amendment is about is going to help you get your head around the particular role and the peculiar role that the Supreme Court holds in the American system. Now, a lot of people go through life without ever looking at the Ninth Amendment, and well, that's their prerogative. I like to drill into it because it opens the door to these rights that are not easily identifiable in the Constitution. Now, it's worth noting that this first was mentioned in Bowers versus Hardwick in 1986. But when that was mentioned, they were drawing upon cases from 65 and from 1937. So the Ninth Amendment says, look, okay, we've banged out 1, 2, 3, 4, 5, 6, 7, 8 rights. The Ninth Amendment says we're going to have some more. And the 10th Amendment says, okay, if it's not detailed here or if it's not being claimed elsewhere, then essentially the rights can be claimed by the state or by the people. So again, this all harkens back to that wonderful phrase from Madison about the powers of the federal government being few and defined. The Ninth Amendment says, look, there are going to be other rights out there, and we'll deal with those as and when they come up. The 10th Amendment says if it's not in the Constitution, then the federal government can't do it. So those rights attend either to individuals or to the states. But let's just focus on the Ninth Amendment. So we've got those 1, 2, 3, 4, 5, 6, 7, 8 original Bill of Rights, and we can probably add to that the 13th Amendment, the 14th Amendment, and the 15th Amendment. Oh, there we go. These you'll know as the Reconstruction Amendments. But then as we get into the 20th century, we start to see more and more focus on what rights people may or may not have above and beyond those enumerated rights. And so in 1937, a new set of rights was identified in Palco versus Connecticut. Now, you don't need to know what Palco versus Connecticut was about. That's not entirely relevant. What you need to notice, however, is that the Supreme Court identified a different bundle of rights. Rights that are not enumerated, but are rather implicit. They are implicit specifically in the concept of ordered liberty. That there is a difference between order and chaos. And when you have a system of order, then there's going to be various rights that are implicit within that. Again, we don't need to worry about what they are right now. So that was in 1937. As we move into 1965, we see another basket of rights being identified. Again, inferred from the Constitution, specifically in this case, Griswold was Connecticut, deeply rooted in the nation's history and tradition. Now, this right was the right to privacy. There is nothing in the Constitution about privacy. However, in 1965, the Supreme Court looked at the Constitution and they said, well, if you take the First Amendment and the Fourth Amendment and the Third Amendment and all these other amendments and you put them together, then we might reasonably infer a right to privacy. So the court is seeing within the text of the Constitution, between the lines of the Constitution, an implicit right to privacy. Not explicit, not objective, but rather a subjective interpretation of different aspects of the Constitution, thereby inferring a right to privacy. And right away, you should be thinking, well, hang on a second. If this is a subjective assessment of the court, then somebody else might choose to interpret the Constitution differently. And yeah, that's exactly where we're going. So the key point is that we have in our Constitution, or we have in the United States, a set of enumerated rights. 1, 2, 3, 4, 5, 6, 7, 8, 13, 14, 15, 19, etc., etc., etc. So those are your enumerated rights. And then in addition to that, we have another basket of rights, rights not easily identifiable in the Constitution. So they're not in the Constitution, they're not explicit in the Constitution, but if we look at the Constitution in context as an evolving document, then we might reasonably infer a set of rights implicit in the concept of ordered liberty or deeply rooted in the nation's history and tradition. So straight away, we've gone away from the text and we've gone away from the original intent. And instead we're looking at a living constitution, a constitution that has survived from 1789 all the way through 1937, 65, 86, to the point where it is now operating in what we would call a modern society. We are recognizing certain rights. We are recognizing a right to privacy. We are recognizing a right to abortion or reproductive rights in that particular instance. And in Bowers versus Hardwick, the state is, or rather the federal government is looking, the Supreme Court is looking at the Constitution and in Bowers and Hardwick choosing not to identify a right, a constitutionally protected right for gay sex. And that changed when we got into Lawrence versus Texas a few years later, but we don't need to worry about that right now. The key point is that the Ninth Amendment opens the door to inferred rights, rights not easily identifiable in the Constitution, but the Supreme Court has gone in and decided that these rights exist. The problem is, of course, that rights loosely identified or inferred can be just as easily rejected, and that's where we're going to be going with the next batch of analysis. Whew, can be quite hard work, this politics. So, if we're talking about renic rights, renic being rights not easily identifiable in the Constitution, then here are some bangers for you. Griswold versus Connecticut recognises a right, an implicit right to privacy. Roe versus Wade recognises an implicit right to reproductive freedom, control of a woman's reproductive system. Lawrence versus Texas recognises a right for gay people to have sex or not have sex, just like heterosexual people. And Obergefell versus Hodges extends the privilege of marriage to gay couples just as heterosexual couples. None of these rights is explicit in the Constitution. They are all inferred, building upon case history, building upon cultural change, social change, whatever it is. But specifically, they all depend on the observer. They all depend on the idea of the observer looking at this legal and cultural soup and identifying certain inferred rights. It's almost like Heisenberg's approach to law. Anyway, these are the cases that you need to identify, and we'll see how we get on with those as we move into the next phase of our analysis. Right, so as previously mentioned, the Supreme Court is there to bring clarity where the Constitution is vague, or whether that's constructively and deliberately vague, or just where it could have done better in the drafting. And we can look at that through a number of different windows, if you like. We can look at it: federalism, government power, and rights, and that's clearly where we're going to go. Now, when it comes to federalism and state rights, again, we mentioned the 10th Amendment earlier, that whereof the Constitution is silent, the states may speak. And so we can see that in some instances, states are allowed to go their own way, as they currently are with drug liberalization in the United States. So right now we've got a patchwork of drug laws across the entire United States, for good or ill, but that's just the way it is. Sometimes the Supreme Court accepts that and says, okay, let's go down state rights, as we're doing with Shelby and with Crawford, where basically we're seeing big chunks of the Voting Registration Act of 65 being dismantled. So there we're seeing state rights. In Dobbs, what we're seeing is the liberalization or the deregulation or the federalization of abortion. Whereas in 1973, the Supreme Court said, no, one size fits all. You cannot make abortion illegal. In the Dobbs ruling of 22, the Supreme Court reversed its position. It did a whole pivot on the issue of abortion and said, no, state rights. If the states want to ban abortion, that's entirely within their jurisdiction. There is no implicit constitutional right to reproductive freedom. That's just not there. So in that instance, we see the Supreme Court holding forth on state rights. In terms of federal power, we can look at the Supremacy Clause and the Commerce Clause. Now, the Supremacy Clause not massively important. The Commerce Clause massively important, as this was the main reason or the main tool by which the federal government imposed civil rights reform across the wider United States. But I don't have time to go into that in this particular presentation. Do look at my video on federalism, which I'll link off to, and you can look at that if you really want to dig into the Commerce Clause. Because really where I want to go, it's not the Elastic Clause either. What I want to go into is the whole question of rights. We have our enumerated rights, one however many through it is. And here we see the Supreme Court moving in to determine exactly what those rights mean. So in Heller, we're looking at gun rights. In Penry versus Liner, Atkins versus Virginia, we are looking at the execution of those who may not be fully aware of the magnitude of their malfeasance. In SKRS, we're looking at the execution for crimes committed when the perpetrator was a minor. So in Penry versus Liner, Atkins versus Virginia, the court did a pivot. In Stanford versus Kentucky, Roper versus Simmons, again, the court did a pivot. Glossop versus Gross, what is cruel and unusual? Again, that same point. All the way through here, the court is bringing clarity, in theory, to gun rights, execution protocols, all of that sort of material. Now, whether or not you think the decision the court reached is right depends entirely upon your political position, because these are not legal questions, these are political decisions. And I'll get into that in a bit more detail when we look at Heller and gun rights later. When we come to rights not easily identifiable in the Constitution, well, I've already mentioned all of those. The key point here is when we're deciding what it means and we're making a political decision, then obviously that's not a definitive political decision. What is cruel and unusual? That's an entirely subjective position. Similarly, what does the Second Amendment actually mean? That's a subjective position as well. You can't bring legal clarity to things that are entirely subjective. When we get on to the Renick converts rights not easily identifiable in the Constitution, the problem is then now you see them, now you don't. Again, it depends who's making that decision. And we see how the Supreme Court can change its position depending upon who's on the board. And again, what that demonstrates is that these are not legal decisions that the court is making, rather the court is making political decisions. And in a democracy, in theory, the final arbiter of a political decision should be democratically accountable. But that's not the case here. And so we're seeing those who are not democratically accountable making final political decisions. Again, I refer you back to Nicholson 2016 in the UK, where the Supreme Court demurred, making that political decision. So let's have a go at establishing what the Constitution actually means. And we're going to do that through two amendments, the First Amendment and the Second Amendment. And we're going to try to look at what a textualist interpretation would look like, what an originalist interpretation would look like, and what a loose constructionist position might look like. And let's start with the First Amendment first. The First Amendment says Congress will make no law abridging the freedom of speech. Now, obviously, there are more bits, but let's just focus on that particular bit. So, are we going to live in a situation whereby we have absolutely no law restricting freedom of speech? Well, what if I decided to use my freedom of speech to sell secrets to a foreign power? Or what if I decided to use my freedom of speech to incite, a riot or a murder or something else? Well, this was very much the position that the court was looking at back in 1919, where an espionage case, which basically was Schenck, somebody was trying to defend their decision to sell secrets to a foreign power, a hostile foreign power, under the First Amendment. And the Supreme Court said, no, that's absurd. We are living in a concept of ordered liberty. And that means that you can't go around saying anything you like. There has to be some form of limit. And so starting, if you like, from Schenck, which said we're not going to let you sell secrets to a hostile foreign power, all the way through to Snyder versus Phelps in 2010, Snyder versus Phelps in 2010, where the Supreme Court upheld the right of the Westboro Baptist Church to protest and boycott outside military funerals on the grounds that they were making a political argument. We have created an environment where it's virtually anything goes, apart from inciting a riot. If you want to go from this position where we are now, which is essentially an originalist position, with an awful lot of freedom of speech, particularly on the internet, online. There is a vast amount of freedom of speech being perpetrated online, for good and for ill. If you want to go in and police that, then you're going to have to move from an originalist position to a much looser interpretation of the Constitution, a sort of living Constitution, where you're saying, well, okay, the Constitution was written in 1789, and that was when the worst thing that could happen with the exercise of freedom of speech was that you might, tell somebody to beat somebody else up, or your actions were limited by context, by the fact that you couldn't go online and perpetrate a lie that would be around the world in seconds. We're seeing here a situation where our Constitution is now looking woefully out of date against a very, very different environment. The Supreme Court right now, of course, is 6-3. Those 6 are largely originalist, and so we're going to see a massive reluctance on the court to choose to go forward and perhaps try to regulate the internet. And how they're going to do that practically is, of course, an entirely different thing. But setting aside that practical application, there is this principled objection to that regulating speech is not within the jurisdiction of this particular Supreme Court, above and beyond what is on offer here. So getting above and beyond that would mean moving from an originalist position to a more loose construction, living constitution approach, and that's not going to happen. Exactly the same way as this isn't going to happen anytime soon. Now, let's have a textualist approach to this. Textualist, well, it doesn't make sense because, A, this makes no sense anyway. What are all those commas about? B, how can you regulate a militia without, in some level, infringing the people's right to bear arms? So a textualist approach to this is entirely bonkers. Instead, we move to an originalist intent. Now, this is kind of unhelpful because it doesn't really establish whether or not this first bit here, my battery's running low. Hang on a sec. Crisis averted. It doesn't really establish whether this bit here, the first bit, is prefatory or substantive. Is that just a bit of cladding, or does that really mean that as long as you're in a militia, you're allowed to have weapons, or if you're not in a militia, are you allowed to have weapons? Again, it doesn't really help, and I'll explain exactly what that means in a little while. But we seem to be in a position now where essentially the Supreme Court has decided that the right of the people to keep and bear arms shall not be infringed, and that is the way it is, because again we're looking at the 6-3 original split. If you want to get beyond that and say, well, hang on a second, that was written in 1789 when we didn't have assault weapons and school shootings, you're going to have to move away from an originalist interpretation to say, but there are bigger issues at play here, and maybe we need to accept that the Constitution was written in 1789. The amendment process isn't going to allow us to change the Constitution, and so we need to stretch the Constitution to adapt to a more modern interpretation of what the Second Amendment might mean. That's not going to happen in the current administration, and so we're stuck at this position here, where essentially the right of the people to keep and bear arms shall not be infringed. And we're looking at, well, Heller is obviously my go-to case on this, and I absolutely adore this. This is from this amazing book here from Peeler et al. And this, in many ways, will help you to understand exactly what the Constitution means. And that was rather stupid. Let me just get that text right back for you. This is one of those occasions where it's tempting to read the text back to you, but I won't do that because I know you can all read. But the key point here is that here we have Scalia, and he produced a 64-page opinion on this particular bit of legislation or regulation from DC. Now, what this regulation said was essentially, yes, you can have a gun, but it needs to be kept in such a state that it can't be picked up by a toddler and used to shoot you or indeed anybody else. So essentially, yes, you can have a gun in the house, but the gun has to be kept over here, and the ammunition needs to be kept over there, and the gun has to be unloaded, and everything needs to be locked away. Now, did that infringe your right to keep and bear arms? Well, according to Scalia, yes, it did, because he went back and he looked through all of these very, very detailed texts, and he said, yes, when we drill into all of these, quite clearly, this regulation or this statute is incompatible with your right to keep and bear arms. You should be able to keep your arms in such a situation that a toddler can pick it up and blast you away. Based on his interpretation of the history, of the precedent, of the context. Just to be on the other side, Breyer and Stevens went off and they did a different analysis of the text. And so we now have another 100 pages. So we're up to 164 pages. But of course, because Breyer and Stevens were progressive judges, when they went and had a look at the historical context, they came to a very, very different conclusion, that this was entirely compatible with the Founding Fathers' intent, and this legislation was utterly valid and should be maintained. Now, the key point here is that originalism is an attempt to achieve some sort of objective position on what the Constitution means, that we can go back and we can somehow exhume history and we can say for definite, this is what the Founding Fathers wanted. Here we see this lie exposed for what it is. We have a detailed explanation. We have 64 pages saying, no, the Founding Fathers wanted this. Then we've got 100 pages on the other side saying, no, the Founding Fathers wanted that. And so, like all history, we find that it's entirely subjective. Originalism is no more objective than my interpretation of Tottenham being the world's greatest football team, even if I know it's absurd. The point is that originalism is an entirely spurious claim to legal certainty. Really, it's just a way by which judges can project their own interpretation of history and law onto a political situation. It is a political position. It is a political judgment on a political question, and therefore it's a political answer. But it's being made by people who are not politically accountable. And so therefore it raises all sorts of very, very significant and important questions about who is responsible for managing the constitutional settlement of the United States and the civil state that subsequently emerges. So, what does the Constitution mean? Well, whoever gets to decide what the Constitution means is basically in charge. They get to decide whether or not you can carry a gun, whether or not you enjoy reproductive freedom, what it means to be gay, whether you can smoke drugs. Some of these are matters of choice, others are not matters of choice. And again, I would direct you towards more perfect, and specifically here the position of Anthony Kennedy, if you want to drill into that in a little bit more detail. We are looking for legal certainty. when we're looking for legal certainty, we can look at textualism. Now, textualism probably has the strongest case for being legally certain, but even then we find there are problems. You know, and it does limit the role of the judiciary to the greatest extent. But, you know, the Constitution is not a perfect document. You know, it has ambiguity within it. Sometimes ambiguity by design, sometimes ambiguity by mistake. And so this is really of an intellectual or rhetorical position. I think it was Scalia who described it as a morally bankrupt position. So no one really is a textualist. It's not something you can really hold to. The closest we've got is Thomas, but not even he would describe himself as a hard textualist. Rather, he'd describe himself really as an originalist. And when we look into this, it looks appealing. It looks like a decent sort of middle ground between what the text says and the original intent. But when we drill into it, we see these claims to certainty are entirely bogus. We're just identifying political positions dressed up as objective statements. And again, it does hold the country to a 19th century standard, which doesn't make any sense at all. Certainly not in a world with nuclear weapons and the internet and assault weapons. You know, we need a more up-to-date solution. But if we're then going down the loose construction route, then we are handing over a prodigious amount of power to judges, and they do become, you know, the de facto architects of the civil state. And we know the judiciary operate outside the system of checks and balances, and so that raises profound questions. And, you know, all of these questions keep coming up, whether it's structural issues or rational issues or cultural issues, all the way through. We run into significant problems when we try to assess the role of the judiciary in the United States. And you can pause and read all of those because I don't have time really to go through all of that. Before we go, let's just drill into again that issue of reproductive rights in the United States. Now, we start off not with Roe v. Wade, but we're going back to Griswold versus Connecticut, 1965. So at this point, when it comes to reproductive rights, you know, there are reproductive rights in the United States, but they're a patchwork. So some states allow abortion, other states don't allow abortion. And then we get into 1973, and we of course have Roe v. Wade. And in Roe v. Wade, the Supreme Court looked at a load of legislation in Texas that was banning abortion, and they said, no, you can't do that. Building on Griswold versus Connecticut, we recognise a right to privacy, we recognise substantial due process, and we recognise that that extends to a woman's reproductive freedom as much as it does any sense of privacy or any other form of privacy. And so we recognise in the Constitution an implicit right for a woman to control her own reproductive system. And any law, any legislation, state or federal, that gets in the way of that is unconstitutional. We then move to 1992. And in Casey versus Planned Parenthood, the Supreme Court looks at different legislation, in this case, legislation from Pennsylvania. Now, what the Supreme Court decides here is you can't ban abortion. That would be incompatible with the decision that they reached in Roe v. Wade. But that doesn't mean that you can't make it difficult. And so we have various regulations, or rather it opens the door to the regulation of abortion providers, specifically TRAP laws, the targeted regulation of abortion providers. And after Planned Parenthood, these escalate and spread across the entire United States. And in Gonzalez versus Carhart, we see federal legislation making abortion difficult, being upheld as well. But then, lo and behold, Whole Woman's Health versus Hellerstadt, the Supreme Court pushes back, and these TRAP laws are declared incompatible with that reproductive right. So we can see here how this is a dynamic model, and it all depends on who's on the Supreme Court. The Supreme Court, the membership is changing all the time. And so at each stage, we've got different people being asked the same question, and so you're going to get a different answer. To the extent that here in 2022, the Supreme Court, having gone from, in 1992, I believe it was 5-4, all the way through here, 5-4, and now it's 6-3 with a Conservative majority. You ask the same bunch of people, different bunch of people, the same question, chances are you're going to get a different answer. And we see here, the Supreme Court turns around and declares that abortion or reproductive rights are not implicit in the Constitution. And so we're back to a patchwork where states are doing what they want. It's exhausting, but this is the way that the United States Supreme Court works. So what do we learn? We have judicial rule in the United States. SCOTUS is outside that system of checks and balances. You can't do anything about a judicial decision that's been reached by SCOTUS other than wait and try again and ask a different bunch of people the same question. They are answering political questions, and if you're asked a political question and you've been appointed for political reasons, then you're going to deliver a political answer. Rights loosely constructed can be just as loosely deconstructed. And that is obviously a problem when you're looking at all of those rights not easily identifiable in the Constitution. Interesting point here that has just come up really in the last few weeks is that the courts lack any power of enforcement. And we've seen that with Trump and the way in which he has ignored rulings from the bench. Obviously, if what you're seeking to do is to regulate to ban abortion, that's essentially a moot idea. But that might get interesting. We'll see how that one follows. How might any of this be useful? This is perhaps the last bit. I'll leave you with this. When you're looking at American politics and you're answering a question on American politics, then you're going to start with the Constitution. And the Constitution establishes tension, whether that tension is between different branches of government or between the federal government and the state government. The Constitution sets up that tension because of all of the compromises and the concessions that it contains. The next round is essentially how those operators try to manage that particular thing. So look at what's happening at the minute. You've got a Congress that's not legislating, and so the president is passing executive orders. So that's how you get around that congressional logjam. But then you need to work out, well, who's actually right here? Who's operating in the way that is consistent with the Constitution? And then that brings us back to SCOTUS. SCOTUS is the final arbiter of constitutionality. Are these executive orders legal? Does Congress still have the right to manage the federal budget, to allocate aid, to spend money? This is where we're going to be going over the next few weeks. I'm recording obviously in April, where everything's still up in the air. But if you think about here, the first round of your essay is going to be about how the Constitution establishes tension. The next round is about how those agents operate within that model, and the liberties they take and the lines they cross and the grey areas they exploit. Then ultimately it comes down to SCOTUS deciding which way round this is all going to work. And that's a fairly lengthy and hopefully comprehensive and helpful analysis of where we are with the Supreme Court. Do please let me know of any questions you've got. I've covered a lot of ground there. I'll always think I could have done it slightly more clearly. But comments, questions, let me know and I'll roll with that. In the meantime, take care and good luck to all the viewers of you who have got exams coming up in the immediate future. Let me know if you've got any urgent questions. I'll deal with those as best I can. All the very best. Bye now.